All right, so we're going to get started. Welcome, thank you all for coming to this first constitutional conversation of the Stanford Constitutional Law Center for this academic year. We're so happy to see all of you. Tonight we are very lucky to talk about a book that just came out in the past couple of days, last month, about Medellín v. Texas, International Justice, Federalism, and the Execution of Jose Medellín, with our author here, Alan Mygatt-Tauber. I think I know. Okay, I get a thumbs up from his wife, so I agree. But I actually won't be introducing him, the topic, or the book, because we are very lucky to have Alan Weiner, who went to the Stanford Law School, graduated in 1989, the director of the Stanford Program in International and Comparative Law, and the director of the Stanford Center on International Conflict and Negotiation. You have a very long and impressive resume.
I wrote it myself. Some of those things are even true.
Oh, okay, good. I hope I hit on a couple of the tracks. But I think it's worth noting that before he came back home effectively in 2003, he was the legal counselor to the U.S. Embassy in The Hague, and the attorney advisor and the Office of Legal Counsel Office of Legal Advisor to the U.S. Department of State, which I think positions him particularly well to comment on the book and on this conversation, which is what he'll do. He'll both introduce our speaker and then have a moderated conversation. And then once they finish up, you guys should feel free, and I'll indicate to you to queue behind these mics, and we'll have about half an hour for Q&A. So please join me in welcoming both Alan and Alan.
Morgan, thank you very much, and it's great to see folks back resuming in-person scholarly discussions and events, and I'm so glad that you're able to be with us. Allow me to have the honor of introducing our speaker this evening. As you've heard, Alan Mygatt-Tauber is a practicing attorney and author. He received his JD in 2004 from George Washington University School of Law. He later went on to earn a master's in political science from the University of South Carolina, where his graduate work focused on the application of international law in U.S. courts, a theme I think that you'll see informs some of his writing and, of course, this book itself. If you're interested, for the law students here in his professional pathway, during law school he interned at the Department of Justice in the Constitutional and Specialized Torts Division, as well as in the Civil Appellate Division at DOJ. I was in the Civil Rights Division at one point, at one of my summers. He's published a number of law review articles on extraterritorial application of the U.S. Constitution, including The Empire Forgotten, the application of the Bill of Rights to U.S. territories, 90 Miles from Freedom, the rights of Guantanamo Bay detainees, and the susceptibility of municipalities to suit under the False Claims Act. For the last 5 years, he's been working as an attorney for the federal government, in addition to writing the book that we'll hear about today. He currently serves as counsel for Naval Supply Systems Command, Fleet Logistics Center at Puget Sound in Kitsap, Washington. He's also serves as an adjunct professor of political science at VCU at Virginia Commonwealth University. Fun fact, little secret information, I understand that Mr. Mygatt-Tauber's first job was working in the payroll department here at Stanford University, and it is said, wait for it, he alphabetized timesheets for his mom, who was the manager of payroll for a number of years. The book that Mr. Mygatt-Tauber is going to be talking about today, Medellín versus Texas, is the result of 7 years of research and writing. Draws heavily on interviews from representatives of the parties at both the International Court of Justice, where the Vienna case was litigated, and the U.S. Supreme Court, including Mr. Medellín himself, officials of the government of Mexico, the United States, and the state of Texas. And with that, I ask you to join me in welcoming Alan Mygatt-Tauber to Stanford.
Thank you so much. Thank you, Professor Weiner, for the wonderful introduction. Thank you to Morgan and the Constitutional Law Center for having me. It's very exciting to be here to talk about my book, although now I'm a little nervous because I feel like there's somebody in the room who might know a little bit more about it than I do, but hopefully not. So this book did grow out of my master's thesis work, which examined the decision-making of U.S. courts in cases involving international law. What I found was that all things being equal, courts deferred to the position taken by the executive. So if the executive said, hey, we should uphold this treaty or this particular decision, courts were like, okay, great. And if they said, no, we want to, maybe not grant sovereign immunity in this case, or we don't want to recognize this particular application of a treaty, courts would say, great. And that was true whether or not you were talking about Antonin Scalia on the right or Ruth Bader Ginsburg on the left. So this is not the largest data set in the history of the world, especially at the Supreme Court. It's maybe 43 cases or so since 1954 when the data set starts. So the ones where Uncle Sam loses kind of stick out. And Medellín is one of those rare cases where Uncle Sam did not get exactly what it wanted. And so the question that really rises is who decides. And this is actually implicated in three separate ways by Medellín versus Texas. First, under the Anti-Terrorism and Effective Death Penalty Act of 1996, there's the question of who should decide whether constitutional rights have been violated, state courts or federal courts. AEDPA really has a bias in favor of state courts and the finality of state court decisions. Secondly, implicated here is the question of who decides, the president or Congress, when it comes to enforcing our treaty obligations. As we'll talk about in a little more detail later, in Medellín, President Bush shocked the world when he decided he was going to side with the International Court of Justice's Vienna judgment against his own home state of Texas. As my favorite line in the book, in fact, comes from John Bellinger, who was the legal advisor of the Department of State, and prior to that worked for Secretary Rice when she was the National Security Advisor. And he said, I'm not sure who was more surprised, liberals who couldn't believe President Bush was ordering compliance with an ICJ decision, or conservatives who couldn't believe that President Bush was ordering compliance with an ICJ decision. So that was honestly one of the reasons I wanted to write this book. I was like, what happened there? Why did President Bush make that decision? But the other question of who decides that's implicated by Medellín versus Texas, and the focus of my talk today, is who gets to decide what a treaty means? Is it the United States Supreme Court and domestic courts in general? Or is it the International Court of Justice, an international body which has, in the words of the optional protocol, compulsory jurisdiction over the meaning of the Vienna Convention on Consular Relations? So Medellín versus Texas arises out of Article 36 of the Vienna Convention on Consular Relations, a treaty that the United States was largely responsible for creating. Basically, it largely just codified existing customary international law, and it deals with what are the rights and responsibilities of consular officers working in foreign states. Article 36 deals with what happens when a foreign national is arrested by what's called the receiving state. In this case, what Article 36 1b provides is that if a detained foreign national asks, then the law enforcement agency that has detained him shall, without delay, inform his consulate that they have detained him, so they can provide legal assistance or other sorts of explanations. Because oftentimes, if you're a tourist in a foreign land, you may not be as familiar with the American legal system, for example, as a Stanford Law student or professor is. So you might want somebody who lives here, who works here, who studied our laws, to come to your aid when you are engaged with our law enforcement personnel. To give that right some teeth, Article 36 1b also requires that the authorities shall inform the person concerned without delay of his or her rights under this subparagraph. So in other words, along with telling you got the right to remain silent, you have the right to an attorney, anything you say, all the good Miranda stuff we've all seen in way too many episodes of Law and Order, if they know or have reason to suspect you are a foreign national, police officers are also supposed to tell you at the state, local, and federal levels that you have the right to contact your consulate. And the Mexican government has one of the most extensive consular systems in the world operating right here in the United States, primarily in states like California, Arizona, New Mexico, Texas, places where you're likely to find a lot of Mexican nationals traveling. Paragraph 1c of Article 36 states that consular officers have the right to visit a national of the sending state, which is basically their national, who's in prison, custody, or detention, if they so ask. So there's a corresponding right there. I have the right to ask, they have the right to visit. And then finally, paragraph 2 of Article 36 follows customary international law and recognizes and acknowledges that the rights contained in paragraph 1 shall be exercised in conformity with the laws and regulations of the state where you're being arrested, provided, however, that those laws and regulations must enable full effect to be given for the purposes for which the rights accorded under this article are intended. So the rights don't necessarily displace U.S. law, provided that U.S. law doesn't prevent you from exercising your rights fully. So in general, U.S. law will win unless, or will operate in conjunction unless there's an irreconcilable difference between the two, at which point the treaty says you still got to give them their rights to speak with their consulate. So as I mentioned earlier, there was an optional protocol that was written along with the Vienna Convention, and this allows any state who opts in that says disputes arising out of the interpretation or application of the convention shall lie within the compulsory jurisdiction of the International Court of Justice and may accordingly be brought before the court by an application made by any party to dispute being a party to the present protocol. In fact, the United States government was the first party ever to bring a suit under the optional protocol for a violation of Article 36 against the nation of Iran following the Iran hostage crisis of 1979, when the student revolutionaries took over our embassy and held our personnel hostage for 444 days. We said, hey, that's not right. There's a treaty that we're a signatory to, that Iran is a signatory to. We're going to the ICJ to get our rights vindicated. Article 3 of the U.S. Constitution, of course, also provides for judicial review of things. It provides the judicial power shall be vested in one Supreme Court, and such inferior courts as Congress shall from time to time ordain and establish. So this raises the question, well, okay, we've got a treaty on the one hand that says that the ICJ has compulsory jurisdiction if the parties agree to make a binding determination on what is the meaning of the Vienna Convention on Consular Relations. And then we have Article 3, which says, well, U.S. courts have the judicial power, however defined. So that has led to some tension between the organizations. The first time it came up, the Supreme Court decided a case called Breard versus Green. Angel Breard was a citizen of the nation of Paraguay. He was arrested, tried, convicted, and sentenced to death in the state of Virginia. And wouldn't you know it, the Virginia police who arrested him neglected to inform him of his rights under the Vienna Convention. As a result, he did not raise his rights under the Vienna Convention because he didn't know he had them. And unfortunately, for a long time, this was in the mid-90s, not a lot of defense attorneys knew about the Vienna Convention either. So his lawyer didn't raise it on his direct appeal or on his initial habeas appeal. The nation of Paraguay found out about this. They raised suits. They sued the state of Virginia in court. Breard brought an emergency petition on what University of Chicago professor Will Bode is termed the shadow docket, what the Supreme Court prefers to refer to as the emergency docket, a last-minute stay of execution, and a cert petition saying, hey, I got these Article 36 rights that were violated. I would like you to stay my execution so we can see if I was prejudiced by that. So things to remember about the shadow or emergency docket. These are cases that are argued without the benefit of full briefing and oral argument. These are almost always litigated in the forms of stay petitions. And in the case of death penalty, usually the day the death penalty is set to be administered. So I'm going to die at 8 o'clock at night. At 8 in the morning, my lawyer's rushing off to the Supreme Court with a stay petition saying, hey, please stay. The state's responding very quickly. The Supreme Court is issuing opinions, sometimes unsigned orders. In this case, in Breard, they did issue a decision. There were I believe it was a 5-4 decision. It was, or maybe it was 6-3. But there were dissents that were noted as well as a decision. But an important thing to remember about these emergency petitions is they're not supposed to be precedential either. They are applied to that case only, and other courts are not supposed to take cognizance of them and say, well, because the Supreme Court said this in response to an emergency petition, this is the law going forward. So what the Supreme Court decided in Breard was that you procedurally defaulted your claim. So procedural default is an idea that respects the finality of judgments, the idea that you're supposed to bring up your claims as soon as you have them or as soon as you become aware of them. And if you fail to raise a claim in a timely manner, you have waived it. You have given it up. You've defaulted it, in this case, in a procedural manner, saying, okay, sorry, you can't do that. The Supreme Court determined that Article 36 claims were capable of being procedurally defaulted, even in the case like this one where the reason it was defaulted was that the state failed to honor the United States' international obligations by informing the defendant of their rights under that convention. They also stated that it's been recognized in international law that absent a clear and express statement to the contrary, the procedural rules of the forum state govern the implementation of the treaty in that state. They also did not decide one way or the other on the question of whether or not the Article 36 provided individual rights. They did say it arguably confers an individual right to consular assistance following arrest, but did not make a determination on that because they were already deciding on the procedural default issue. But there is a long line of cases and arguments in international law that, for the most part, treaties create rights between states. They don't create rights between individuals and states. So if your Article 36 rights were violated, well, Paraguay has a complaint against the United States federal government. You, Mr. Braillard, do not. That was the state of Virginia's position. So Paraguay didn't like this very much, so they actually filed suit against the United States in the International Court of Justice. However, for reasons unknown, they ended up dismissing the case before it got to a decision. As I talk about in the book, there was some interesting timing where Paraguay was being considered for sanctions for failing to violate copyright, and about 2 weeks after they dropped their ICJ case, suddenly the United States announced we've come to an accord with Paraguay and we will not be sanctioning them. So make of that what you will. The next time it came up, however, it did go to a decision of the International Court of Justice. Germany filed a claim known as the Legrand case. This was two brothers, Walter and Karl Legrand, who were arrested, tried, sentenced, convicted and sentenced to death in the state of Arizona. They raised Vienna Convention claims. Germany took it to the ICJ. The ICJ issued what they call provisional measures, which is their version of a TRO, essentially. They said, hey, United States, take all steps necessary to prevent the execution. At this point, it was just Walter Legrand. Karl had already been executed. So this was the day of Karl's execution. The United States says, the Supreme Court heard that, said, that's nice, that's advisory. You don't have to listen to that, Arizona. Arizona said, great, we're not going to. And they executed Walter Legrand that evening. Now, Germany went ahead and went the full distance on their decision. And the International Court of Justice determined that the VCCR, Article 36, provides individual rights, that those individual rights were violated in the case of the Legrand brothers, that the procedural default rule should not have prevented them from raising a subsequent habeas petition, and that the appropriate review was review and reconsideration by a means of the United States' choosing of the conviction and sentence. That was the proposed remedy that the ICJ came up with. Of course, at that point, it was a little late. The Legrands had both been executed by that point nearly a year before. So the United States said, okay, thanks very much, we'll take that under advisement, and we went on with our lives. Well, in 1998, Mexico had started the Mexican Capital Legal Assistance Program. They hired a public defender named Sandra Babcock, who then went on to be a professor of law at Northwestern University. He currently teaches at Cornell, to provide assistance for Mexican nationals on death row or who were threatened with death row. She went around to all the death rows in the country and identified 64 Mexican nationals who had been arrested, tried, sentenced, and convicted and sentenced to death without being informed of their consular rights under Article 36. So Mexico put together a claim. They acceded to the optional protocol, and in their first and only to date suit at the ICJ, they filed suit against the United States and said, you've got 64 of our nationals who are currently awaiting death row. We want the ICJ to determine that their rights were violated under Article 36. And they asked for the remedy of restitutio ad integrum, which means basically restore the status quo ante before the violation of Article 36 happened. So they wanted the ICJ to order the United States to undo the convictions, undo the trials, in some cases undo the confessions that were wrung out of their nationals, and said, hey, they should have been informed. It says without delay. They should have been informed when they were Mirandized that they had the rights to consular assistance. So that means anything you got from them after the second you failed should be thrown out. So the ICJ heard the case, the United States argued and said no. Somewhat of a defensive action, quite honestly. They said, even if we did violate the rights, you made a great decision in Legrand, let's stick with review and reconsideration. So the ICJ heard the case, 15-1, they said, yeah, you violated the rights of these Mexican nationals. And then 14-2 said the appropriate remedy is what we said in Legrand, review and reconsideration, taking account the violation of both the sentence and the conviction. That's what we want. So Mexico was happy. They got a good decision. Honestly, some split opinions on the Mexican team. The Mexican ambassador was quite happy, the legal agent for Mexico was quite happy with the outcome. He thought they got a very good decision. Sandra Babcock felt that, great, what's going to happen is they're just going to put on these sham reviews. They're just going to have a little hearing, say you weren't prejudiced, go away, and we're going to execute you anyway. So there was some immediate fallout from this. The governor of Oklahoma did stay the execution of a Mexican national named Osvaldo Torres to give him time to bring up some evidence that maybe his Article 36 violations had prejudiced him. The Board of Pardons and Paroles in Oklahoma decided, hey, we're going to go ahead and pardon him. We think that was correct, and so his sentence was mitigated down to, I believe, life in prison, which was great for him. Not so great for the Mexican team because that was their choice for who they wanted to take forward because he was more sympathetic. As Sandra Babcock frankly told me, nobody would have chosen Jose Medellín to be their poster boy for Article 36 violations. He committed a very horrific crime. He did it in the capital city of capital punishment, Houston, Texas. Basically, if you were looking to avoid the death penalty, you could not have picked a worse place, a worse crime, and a worse victim than Jose Medellín did. It was like the guy was looking to get the death penalty, quite frankly, just based on where he was, when he was, and just the way the death penalty is practiced in this country, and when the race of your victim is white versus when they're anything else, and when you're either black or Hispanic compared to a white, it's just, you could not have picked a worse situation to be in. And then he confessed pretty much immediately. There was very little doubt that he was guilty of the crime for which he did. He bragged about it to his friend's sister-in-law. He was not a great plaintiff, let's put it that way. But he was in procedurally the right position. He filed a subsequent habeas petition. They had the Avena judgment, and they said, well, we're going to take this all the way. And so initially, the Fifth Circuit said, no, we're denying you a certificate of appealability. So under the Anti-Terrorism and Effective Death Penalty Act of 1996, it really ratcheted down on subsequent habeas petitions. You have a wide range under the federal habeas statute. You can bring claims in violation of law, treaty, constitutional law, things of that matter. EDPA says for subsequent petitions, you can only bring claims of violations of your constitutional rights as defined in decisions of the Supreme Court of the United States. And they don't favor secondary petitions at all. If you didn't raise it, you've procedurally defaulted. They kind of locked that into federal law, the idea of procedural default, or at least allowed the states to run with that. So, and they required that if you're going to appeal a secondary habeas petition, you have to get what's called a certificate of appealability. It's a letter from either your district court judge or the Court of Appeals that says that there is enough of a question here that reasonable jurists could disagree. And so basically you have to get like a letter of permission from the court to even file in court. It's the sort of thing you see with vexatious litigants sometimes. As a sanction, the courts will say, if you're going to file again, you got to get our say-so. So the Fifth Circuit denies it. They appeal. The Fifth Circuit again denies it. It goes to the Supreme Court. The Supreme Court is going to rule on this matter. The state of Texas is saying, hey, this guy procedurally defaulted. He has no rights. Avena's not an enforceable judgment. It's not federal law. The federal government is largely going along with this position until on February 28th, 2005, the day the day that the reply brief from the state of Texas is due, President Bush issues a memorandum to the Attorney General of the United States and says, we're going to comply with the Avena judgment. We're going to enforce the decision of the ICJ, please ensure that the states give for these at this time it was down to 62 Mexican nationals because it turned out 2 of them didn't qualify. They were actually dual citizens, so they couldn't qualify for Article 36 rights. So for the 62 who are remaining, make sure the states give them this review and reconsideration that Avena has said that they're entitled to. Shocked the world. Nobody could believe it. And then a week later, he tells Condoleezza Rice, send a letter to Secretary General Kofi Annan. We're withdrawing from the Vienna Convention on Consular Relations optional protocol, so we can't be sued anymore. This was a case of classic White House horse trading. So folks within the administration had argued, hey, look, we need to respect the ICJ's decision and uphold Article 36 rights because there are a lot of Americans who travel abroad. And we want them to get Article 36 rights. And if we don't grant Article 36 rights, they don't have to grant us Article 36 rights. In fact, there's an explicit escape clause in, I think it's Article 72 of the VCCR, that says that to the extent that your claims aren't being, to the extent that certain states aren't respecting your rights, you don't have to respect them the same way. So President Bush agreed, fine, we'll do that. But the DOJ was adamant. They're saying we're sick of getting sued and losing. So if we're going to do this, you got to give us something, and that is you got to pull out of the optional protocol to prevent us from being sued anymore. And so that was the deal that was made based on the folks I've spoken to from within the administration. And so a week after saying we're going to enforce Avena, we also said we're not going to be sued anymore. Anybody else wants to try to get us, too bad. So we withdrew from the optional protocol. We're still members of the Vienna Convention. You still have Article 36 rights within this country. That is a self-executing treaty. It doesn't require any further action by Congress. Every police officer in this country is supposed to, if they suspect you're a foreign national, when they detain you for any reason, tell you you can call your consulate. That's still true. We just can't be sued for it. So now you have a clear and express statement from the International Court of Justice saying, here is what the Vienna Convention on Consular Relations means. You cannot use, they specifically held in Avena, they gave the same review and reconsideration. They said 3 things. First of all, they said, hey, when we give you provisional measures, those are not advisory. Those are binding international obligations. We mean it. We tell you not to execute somebody. Don't execute them. Secondly, we're going to give you the same remedy you got in, we gave in Legrand, that by means of the United States' own choosing, you have to provide review and reconsideration of the conviction and sentence that provides, that takes account of the constitutional or the treaty violation. And finally, they said, while procedural default does not inherently violate Article 36, in these 62 cases it does. If you use procedural default doctrine to say that they can't get review and reconsideration, well then you're violating 36-2 because the said laws and regulations are not enabling full effect to be given. So that is the now clear and express statement from the ICJ saying that, hey, the general rule about we go along with your laws, that doesn't apply here. So, the Supreme Court's looking at this case. President Bush comes out and says we're going to enforce this. So, Medellín and his team run back to the state of Texas, to the Texas Court of Criminal Appeals, and say, hey, Avena, Bush, you got to give us our review and reconsideration. So the Supreme Court punts. They dismiss the case and improvidently granted and say this was a 5-4 decision. They say, yeah, you might get all of your relief that you want from the state courts of Texas, so we're not going to issue our decision here. Justice O'Connor writes the lead dissent and says, there's a lot here we should probably actually look at. There are very important questions that may not be answered by the state of Texas, like the standards for a certificate of appealability under EDPA, but that did not rule the day. In the meantime, this is working its way back up. Sandra Day O'Connor announces her retirement. John G. Roberts is appointed to replace her. William H. Rehnquist dies. President Bush says, well, hey, I'm going to take John G. Roberts. I'll make him the chief. I'm going to pick to replace Sandra Day O'Connor, Samuel Alito. Let's just say Samuel Alito and Sandra Day O'Connor have very different views about the death penalty, about international law, about, whether or not the police can be trusted to do no wrong. As members of the team for representing Medellín told me, they would have been much better off if they'd just gotten a decision from the Supreme Court in the 2006 case rather than waiting until 2008. So they go back to Texas. Michael Dreeben, the Solicitor General's man who knows more about criminal law than anybody else in the federal government, goes to Texas to argue in front of the Texas Court of Criminal Appeals. He works in the Solicitor General's office. He usually just argues in SCOTUS. He's got over 100 arguments there. He's one of the top advocates of the 20th and 21st centuries, since retired. He goes down to Texas. He argues. Texas writes a decision that says, yeah, no, President Bush doesn't get to tell us what to do. If you want to do that, you need Congress's backing, Mr. Governor. You may have been our governor for a time, and you may have loved the death penalty when you were here, but we don't have to listen to you now. So it goes right back to Supreme Court. There was zero doubts amongst anybody on either side that this was going to get decided by the Supreme Court a second time. So it goes back up for now known as Medellín versus Texas. Senator Ted Cruz at the time was the second Solicitor General of the state of Texas. He argues the case. He's very, very proud of this case. He talked about it extensively. If you remember when he was running for president in 2016, he mentioned Medellín versus Texas many, many times on the campaign trail. I've got 200 pages of interviews of him talking about Medellín versus Texas. He loves this case. Wouldn't talk to me about it, though. I don't know why. Loves talking about this case. He goes up and argues. Medellín is represented by the same lawyer who represented him the first time around and who represented him at the ICJ, a lawyer, Debevoise and Plimpton, big New York firm. And then Sandra Babcock is representing the government of Mexico as an amicus. Amicus briefs flood in on Medellín's side from the European Union, a bunch of other Latin American countries, various international law professors, tons of people, about an equal number filed on behalf of the state of Texas, about 25 states filed on Texas' behalf, almost all of them death penalty states, but not all. A bunch of victims' rights groups, and then a brief written on behalf of the parents of Medellín's victims. And then the Solicitor General this time sides with Medellín fully because they're defending President Bush's decision. Well, not fully. They're saying, Medellín's saying, hey, Avena by itself is enough to get me a hearing. The SG's office says, that's not right, but because President Bush sided with you, you should get your hearing. And so that is the decision, that's the argument that's being made. Justice Scalia makes a quip about how jealous he is of his power. It gets a big laugh. The folks were somewhat hopeful on Medellín's side about how the case was going to come out. When John Roberts was a law clerk, he clerked for William Rehnquist, who was the chief who he replaced. He worked on a case called Dames and Moore versus Reagan, which arose out of the Iran hostage crisis. In that case, an 8-1 court with Justice Rehnquist writing, and which I understand Roberts worked on in his role as the justice's clerk, said that the president can, without statutory authority, halt actions in state and federal courts that were suing Iran for compensation because we had agreed with Iran to set up a claims commission. We froze all of Iran's assets in the United States and said any claims are going to be paid out of these assets, but you got to go to the Claims Commission. You can't go to the Southern District of Florida or the Eastern District of New York or the state courts of California. You've got to go to the Claims Commission. This was a decision, 8-1, says, yeah, you can stop. So everybody thought, okay, we've probably got Roberts' decision. We've got the four liberals on the court. We think we've got a pretty good chance here. Well, surprisingly, the court comes out 6-3 in favor of the state of Texas. 5 justices decide, written in an opinion written by Roberts, that said, no, there's a difference between self-executing and non-self-executing treaties. A self-executing treaty is one that goes into effect without any further effort by the United States. A non-self-executing treaty requires some sort of congressional action before you can file under it. And neither the ICJ statute, the optional protocol, or the UN Charter, which talks about how you enforce ICJ decisions, are self-executing, and Congress has never bothered to pass any laws to that effect. Although the Vienna Convention is self-executing, for some reason Medellín didn't rely on the Vienna Convention itself in his arguments. He explicitly pointed to the ICJ statute, the optional protocol, and the UN Charter. So they said, sorry, that's great. They might be entitled to respectful consideration, but we in the United States, as the Supreme Court, have the final say on what U.S. law is. By the way, treaties, yes, they're the supreme law of the land, but they're on the same level in the Constitution as federal statutes. There's a long-standing rule in treaty interpretation that the later in time controls, and The Vienna Convention was ratified in 1969, and the Anti-Terrorism and Effective Death Penalty Act was passed in 1996. So to the extent that there's any problem there or any conflict, EDPA wins because it's later in time. And so it was that Medellín was then put to death. They were allowed to go through with their execution. Twice now, the Congress has tried to pass statutes that would implement Avena. First in 2008. That one never made it out of. That one even got referred to committee and died a very quiet death. In 2012, Senator Patrick Leahy brought up a version of a bill, a Consular Notification Act, that would allow for, it would amend EDPA to allow you to raise a specific claim that your Vienna Convention rights had been denied in the event that you had not originally been informed of them. That one made it all the way through committee hearings and then didn't get out of committees, and that was in 2012. And since then, the issue has laid fallow. So the ICJ has only gone back once in a case between India and Pakistan called the Jadhav case. There they said, yes, review and reconsideration, but they explicitly said, and to the extent you need to, pass a domestic law to give this effect. Now the interesting thing is, it was a 6-3 decision. The 5 ruled the way I did. I said, Justice Stevens wrote a concurring opinion in which he said, yeah, you don't have to do this, but you probably should. Texas, it'd be really easy for you to do this, to uphold the honor of the United States. So give the guy his hearing, but I'm not going to say you have to. I just think you should. And then the dissenters said, are you guys out of your mind? The ICJ said this is what the treaty means. There are a ton of treaties we are a part of where we give ultimate decision-making to third parties that are not United States courts. So if you're saying Article 3 invalidates all of them, that's going to cause us some real foreign policy headaches in the future. So that's where it lies. The decision has never been overturned. And so, yeah, right now, within the United States, it's interesting, though, all 9 acknowledge that there was a violation of international law here. The United States was in violation. It was only compounded with every execution. But right now, the United States' honor belongs in the hands of the 700,000 or so individual law enforcement officers that are working on the ground and potentially stopping foreign nationals who may or may not give them their rights under the Vienna Convention.
Super. Well, Alan, why don't you sit down and have a couple of questions for you, and then we'll open it up. Thanks very much. As noted, I was the U.S. government's legal representative in The Hague when the Breard case and the Avena case and the Legrand case were filed. In fact, the Legrand case, we got a phone. The case was filed actually only about 36 hours before Legrand's execution was scheduled. And I was at the office, and I got a call saying, okay, there's an application coming from Germany. Can we bring it to you at your house tonight? And they did. A driver from the court came to my house at about 9 p.m., and then I went into the embassy and started faxing it back, because we used fax machines. Once upon a time, there were telefaxes to send this back to Washington. So let me just ask, I want to make sure we have time for people who came to ask questions, but let me ask one kind of legal or doctrinal question that's always, there's a number of things that have vexed me about the Medellín case. One of them is the focus, the question about the relationship between procedure, and more precisely, federal procedure on the one hand and substance on the other. I mean, you concluded with the observation that all of the justice involved in the case recognized that the United States had violated obligations that it owed to Mexico and, at least plausibly, to the Mexican nationals. The issue was whether or not they could avail themselves of a particular form of collateral review, habeas review, after their initial claims had been filed in state courts. And again, you identified the relationship between the later in time statute. EDPA, by the way, if you live in Europe and you have to go to Europeans and say, we have a law called the Anti-Terrorism and Effective Death Penalty Act. That's a tough ticket to sell with Europeans. Oh, we want to make our death penalty more effective. But the bottom line is, we have a supremacy clause in the United States. right? Treaties are the supreme law of the land. Our obligations under the Vienna Convention, which were violated here, take precedence over state law. So why weren't the several states obligated, quite apart from habeas review, directly to give effect to the decision? Right? Why is this an issue of federal law in the sense of whether or not courts have jurisdiction or whether or not President Bush's memo counted as law? Why wasn't Texas obligated under Article 6 of the Constitution?
Well, so that's an interesting question, because Article 6, the supreme law of the land includes treaties specifically because under the Articles of Confederation, you had states, sovereign states, violating the 1783 Treaty of Peace with Great Britain and threatening to throw us back into the Revolutionary War. So they said, hey, we want to knock this off. The answer is they are. But, Rick Perry's, he was the governor who followed President Bush. His answer was, it's not my problem. It's the United States' international. I didn't sign the treaty. It's the United States' responsibility to comply with our international obligations. The state of Texas, we don't get to do that, even though we're the Republic of Texas and we like to be, our own little thing. That was their view. Now, I mean, they still are required, I believe, and the treaties explicitly say, or international law says, the federal nature of your how you run your municipal law doesn't affect your international obligations. And so Texas should have been, and in fact, that's kind of what Justice Stevens' view is. I think here is where the United States got shot itself in the foot with its previous arguments in Braillard, in the Legrand case, in pretty much every case where anything like this came up. The answer the United States has always said, because they never want to be on the side of the death penalty victim, was we can only do persuasion.
Our hands are tied.
Yeah, in Braillard, they said we sent a letter to the governor of Virginia and asked him to please comply.
We said the same thing in Legrand.
Yes, we said that. And I know that, after we got the decision, John Bellinger says he went back to Condoleezza Rice and followed her and said, we've still got this obligation. We've got to do something. And she said, okay, if you can get Mike Mukasey, the Attorney General, to write a letter, I will co-sign a letter to Rick Perry, and we'll say, hey, we understand what the Supreme Court said. You don't have to, because as a matter of federal law. But this is an international obligation. You have an obligation. You should follow through. And they sent that letter. And Perry said, yeah, thanks. Not my problem.
I think that's one of the most doctrinally vexing parts of Texas's position. It seems like saying, well, international law is no more of a Texas matter than constitutional law is. I mean, that's a federal matter, right? But that's for another day. Let me, I want to open this up, but you got a master's degree in political science, so let me ask you a political science question. Although it's not what you research, so it's an unfair political science question. So the United States lost in Braillard, Legrand, and Avena. We withdrew from the optional clause. We disregarded the court's ruling and withdrew from the optional clause. We've had provisional measures orders issued against us by the court in cases against Iran under the 1955 Treaty of Amity, which is one of the treaties that was the basis of jurisdiction in the hostages case. We've since withdrawn from that 1955 treaty. The United States, in competing around the world, say with China, often talks about the U.S. commitment to a rules-based order. How compatible is the behavior of the United States in this litigation with our stated commitment to a rules-based order?
I would say it's not very much. I mean, that's the thing so I spoke with Harold Hanjuko, who replaced John Bellinger as the legal advice Department of State, and he told me when he worked as Department of State, every time he went to Europe, around the world, people would throw our love of the death penalty in his face. Anytime he's trying to make an argument about human rights, like, well, you execute people, and you do it in a really racist and unfair manner. Why should we listen to you? And so the answer is, it really does undercut our claims. I mean, arguably, if I was taking on the mantle of a State Department person responding, I'd say, well, we did follow our rules. Our laws say the Supreme Court is the final arbiter. They followed the law as it was written, and under our system of government, the president doesn't get to write a memo to the Attorney General and boss the states around. The states are maybe not equal sovereigns, they are also sovereign in our federal system, and so he needs the backing of Congress. That was all Texas was asking for. Congress has refused to act. But as the legal realist that I am, And as somebody with a political science background, I have to say, yeah, it doesn't look great for us.
And hopefully those European interlocutors haven't gotten as far as Article 6 of the Constitution when they have the debate. Over to you, Morgan, to facilitate the Q&A.
And all that I will do is stand up and point to the two microphones with you with you behind them to ask their questions. We are recording it. That would be great. So take it away.
Thank you, Ellen, for a wonderful presentation. I've got two questions, and they're more political. One question is, why did Bush decide to comply with the ICJ? What were the politics around that? I mean, maybe he saw this as low-hanging fruit to actually comply with something in the international order that he was being widely accused of not complying with. And the other question is, on the last decision, to what extent were the judges driven by consequentialism? They had, as you say, a profoundly unsympathetic plaintiff. Did the facts of the case matter in that decision?
Right, well, so to answer your first question, as best as I've been able to piece together by speaking to various members of the administration who were willing to talk on the record, it really was a concern about Americans abroad. There was also a state legislator in the state of Texas who wrote to both the judge who sentenced Medellín and to Rick Perry as well, asking him to delay the executions, at least until the Texas legislature could come back, because it's only a part-time legislature, because he wanted to introduce some legislation at the state level that would have allowed Medellín to get relief under Avena. Again, because Texans do a lot of business in Mexico. And there was a real fear that if we don't respect Article 36 rights, that when our citizens are arrested, they'll be subjected to violations of Article 36. One of the more interesting amicus briefs that I read in the case on the side of Medellín was from Ambassador Bruce Langan, and the guy who authored Midnight Express, made the movie out of. He was arrested in Turkey for drug running, thrown in prison, wasn't given his Article 36 rights. And so they both, and Ambassador Langan had been one of the hostages in Iran. And so they were both saying, look, these are vital rights. These are really important. And Americans depend on them on a daily basis. And so I think that was the argument that convinced President Bush to go against his own home state and his own pro-death penalty instincts. And then as to your second question, consequentialism. So it's interesting. If you read the briefs, the Medellín brief opens up with he was convicted of a crime, he was convicted of murder, sentenced to death, and then all this procedural stuff happened. The Texas brief goes into almost lurid details about the crimes. There's actually, there was some paraphernalia taken from the victims. At one point, it was, I understand it was a goofy watch, but one of the briefs that Ted Cruz wrote calls it a Mickey Mouse watch because, at least according to somebody who was in the office, that was a more evocative idea. If you ever read a death penalty opinion by Sam Alito or Clarence Thomas, they always open with, either in majority or dissent, they always open with very lurid descriptions of the crimes of which people are accused, which shouldn't matter. It's not supposed to make a difference at the legal level. Whether or not the guy was sentenced to death for jaywalking or a horrific multiple murder, the legal question is the legal question. Do we follow the procedure we're supposed to follow? I think consequentialism did play a role. I mean, like I said, Sandra Babcock told me that Jose would not have been her first choice for a plaintiff. They wanted Osvaldo Torres or one of the other folks who, there are cases where there's pretty clear, hey, this guy doesn't read English and you had him sign a confession written only in English. Can we really trust that? Those are the kinds of plaintiffs they wanted. Somebody who was more sympathetic or at least had a better claim that maybe they were wrongfully convicted. I don't think anybody on any side here really doubts that Jose did the crime of which he was accused because, like I said, he went back to his sister-in-law, he bragged about it, he was arrested, he confessed almost immediately. He was Mirandized 3 separate times and waived his rights each and every time. He sat next to the detective as the detective typed up his statement and even corrected some of his spelling errors, at least according to some of the sources I've seen. So, yeah, I think consequentialism played a part.
My question is about the kind of treaty power. So under the 10th Amendment, there are certain powers reserved for the states. My question is, how does that interact with the treaty power of the federal government? So for example, say the federal government wants the state of California to change its state motto or something like that, and California says no, and the Supreme Court says, well, you can't do this. This is California's right. Can the U.S. government then go find, Federated States of Micronesia and sign a joint treaty that no official government motto in any state will do X or Y? And so basically, I guess my question is, does state sovereignty or states' abilities to have sovereignty in certain areas restrict the federal government's ability to sign treaties, and how does that work?
Oh, so the treaty power is not a get out of the Constitution free card, is what it is. So the treaties, the Supreme Court has held on multiple occasions, you can't use treaties to expand beyond what the Constitution allows. So can't have treaties that restrict free speech, can't have treaties that give the federal government power over intrastate commerce. And so the Supreme Court would say that, yes, the 10th Amendment, whatever strength it has, cannot be overcome by a treaty. You would have to then decide whether or not the particular aspect being treated about, the subject of the treaty, was in fact one of those reserved powers that were reserved to the states or the people respectively under the 10th Amendment. So in this case, criminal justice, how you run your criminal system, has traditionally been seen as a core state function. And so that was certainly part of Texas' argument, was you can't get more core to a state's right than how we run our own criminal justice systems. And that was an argument that the majority of the court accepted. So yes, so treaties can overcome state laws to the contrary in areas in which federal law could do so on its own. But we couldn't just find a willing partner and say, hey, yeah, we're going to give you $1 billion in foreign aid if you sign this treaty that says that, Texas has to get rid of qualified immunity.
Thank you.
You're welcome. Thank you for the question.
I have another question about the remedy, the review and reconsider remedy. To me, I'm on Sandra Babcock's side. That sounds like that's so easy to comply with and just say okay, didn't prejudice him, reimpose the death penalty. Texas is good at that. So why the big fight? Why not just give him the hearing and he loses?
That's a question I don't know the answer to. I've never been able to decide. In fact, there was an argument that if you go back to the original habeas petition he filed, the first subsequent habeas petition that he raised that led to the case known as Medellín versus Dretke, which came out before, that was the 2006 case that got digged. There is a line from the federal district court judge that says, in the alternative, I don't find he was prejudiced. So arguably, he got some form of review and reconsideration. Now, the argument that Babcock and Donovan, which was the Debevoise and Plimpton lawyer, were making was that because Avena adjudicated Medellín's rights specifically, Medellín was one of the 64, that clearly if they said he was entitled to review and reconsideration, they didn't consider that he had received it yet. But why the state of Texas couldn't just, and that was Justice Stevens' point too, in Medellín versus Texas, was, guys, it's not that hard. Take a day, have a hearing, make a ruling. And that really was the fear. But for whatever reason, Texas, it's interesting. Ted Cruz was, he was a Harvard grad. He clerked for I think it was Ludig. He clerked for Ludig on the Fourth Circuit, and then he clerked for Chief Justice Rehnquist. Everybody says he's a really sharp guy. He's not the wacko bird that he was dubbed by John McCain until he starts running for Senate. But he's hired by Greg Abbott, current governor of Texas, at the time Attorney General governor of Texas, and is given a mandate. I want you to turn this office into a conservative flag bearer. I want you to go out and find these cases and take the most extreme conservative position you can, because that's who I am and that's who Ted was. And so that, I think, is wise. Why did we spit in the president's eye? Because we could. Yeah, sure we could, but you told us to. And we're Texas, and nobody tells us what to do. I mean, that's the best I can come up with.
Given the time, let's take both questions and then give
Yeah.
Alan a chance to answer. So,
Okay.
hey.
Sounds good. Thanks so much for this really interesting talk. I have two short questions. First, I wanted to ask, and maybe this was touched on in part of these answers before, did you come across in your research why the court granted cert the second time? This is like, we've discussed, it's like a really unsympathetic plaintiff. It's a really complicated case, and there was a real risk of like getting the law wrong. So why did they grant cert and not just leave it with the Texas Court of Criminal Appeals? And then second, do you know of any states that took advantage of Article 72 discrimination of the VCCR since the case was decided? This like reciprocal restrictive application of the treaty.
And then we'll get.
Yeah, let's.
Great. That was his second question was actually one of my questions. So I can move on to a follow-up one, which is prior to the U.S. Withdrawing from the option of Article 36, was the U.S. also litigating cases or bringing cases to the ICJ on behalf of nationals? No.
Oh.
Not at all.
So the only Article 36 case the United States has ever brought was the Iran hostages case. We've brought other cases at the ICJ. We're one of the most frequent litigants at the ICJ on both sides, but never on Article 36. And then, so to answer your questions, no, I am not aware of any state that has yet taken advantage of the escape clause to not provide, at least they've not. If the state's not going to provide it, they're not going to provide it to anybody. But nobody's pointing at the escape clause saying, well, you don't do it for us, so we're not going to do it for you. If they're not going to do it, they're not going to do it. And if they are, they just have more honor than we do and say, yeah, you're not upholding your end of the bargain, but we're England, we're France, we're going to be better than you and be able to hold it over your heads. As for why the court granted cert the second time, I think that was laid in the first argument when the United States was asking for the dig, when they were saying, hey, there was a lot of questions for counsel on both sides about, well, hey, if Texas rules, we'll get this back, right? Like we will always have the option to review the Texas court's decision. And the answer given was yes, absolutely you will. And so I think, usually the court grants to reverse. That's the general, knowledge, but I think they just wanted to put this issue to bed once and for all. There were 64 Mexican nationals that were on death row. There were hundreds of foreign nationals, California, Texas, Oregon. The Death Penalty Information Center has a ton of information about the foreign nationals who are sitting on death row, and I think they just want to stave off all these. Okay, they didn't want a bunch of more Breard and Legrand petitions coming their way, so they could just say, lower courts can just say, yeah, no stay. Look at Medellín, and so I think that's why they did it.
So Medellín turns out to be a really significant case, in part because of the way it modified our understanding or shaped our understanding of what a self-executing treaty is. When can a treaty be given effect automatically by the courts, and when does it require legislation enacted by Congress? But I think it's been quite really fascinating to hear the kind of tortuous and complicated and rich journey about how that case was decided. So I think that this has been a really, really wonderful lesson for us all. And I'd like to ask you to join me in thanking Alan Mygatt-Tauber for